Okay, we're going to get started. If everyone could be seated, that would be wonderful. Good afternoon. Some of you may remember from the beginning of today's session. My name is Erik. I'm the Symposium editor for the George Mason Law Review. We have another engaging panel planned. Our next panel is titled Boundaries of Refusal to Deal and Predatory Tying and Bundling. The moderator of this panel is Shahar Dillbary, Professor of Law and Associate Dean for Faculty Research at the Antonin Scalia Law School. Professor Dillbary, the floor is yours.
Thank you so much, and thank you everyone for coming, especially after lunchtime. We appreciate that. We have a great panel today and very exciting. I'm going to jump immediately in. We're going to speak about tying, about refusal to deal, and some of the boundaries between those different doctrines. But Erika, if we can start with you, can you walk us through the element of Section 2 claim, the core requirement of refusal to deal as framed by the Supreme Court, and the role of, if any, that anti-competitive intent plays? So, all yours.
Thank you. So I want to begin with a note of gratitude to our hosts, because it's such a tremendous time to be studying and talking about Section 2. And I hope that the students here realize that we're living in a very exciting time for antitrust law. So I'll take Shahar's question to mean what are the elements of Section 2 monopolization claims, since I think that's where we're focused today. And for this audience, those are familiar elements, right? As classically stated by the Supreme Court in Cornell in 1966, you need the possession of monopoly power in the relevant market, and then also a willful acquisition or maintenance of that power, which, as we who study antitrust know, the court distinguished from the growth or development of that power as a consequence of superior products, business acumen, or historic accident. And for the students, again, in the room, that means monopoly alone is not unlawful. There must be monopoly power and some sort of conduct. So that's the easy part. The hard part is the second conduct element. We can say with confidence that sometimes refusals to deal can violate Section 2. That's where the confidence ends. You know, we might expect the component elements of that violation to be clear. They're not well defined. We can have a whole panel talking about them. Because the courts have left those elements murky. Major refusal to deal cases from the Supreme Court, and I think here I would put Trinco, Aspen Skiing, and Linkline in that category. They don't expressly set out the elements of an unlawful refusal to deal. Instead, they sort of say what may constitute an unlawful refusal and then let us sort of infer some of the specifics. But those cases are clear on the starting point. As a general matter, monopolists have no general duty to deal. They can choose their trading partners. But Trinco makes clear that's not an unqualified right, that courts will find a duty to deal when certain conditions are met. And so here are three that I think get at the heart of the refusal to deal conduct element. So, as the name suggests, there has to be some sort of act by the defendant where they're declining to engage in a business dealing, so often refusing to sell goods or services. And that sounds straightforward, but we can already begin to debate if we are going to include complete or simple refusals to deal at all with rivals, or also conditional refusals where the monopolist is willing to trade, but only on certain conditions. And this is sometimes dichotomized in discussions, but I think it's probably more of a continuum where if the conditions become harsh enough, it starts to look closer to an absolute refusal to deal. And whatever the defendant is refusing to deal in, be it access to digital platforms or a joint ski pass, as in the famous allegations and cases, it has to be important to the rival's ability to compete. So that competition-relevant refusal is at least the first key element. And I think the second one is that that refusal has to be directed at an actual or potential competitor. This has become important in recent cases. Okay? Refusals involving a purely vertical supply relationship are not going to be prohibited under this doctrine. So when we say refusal to deal, we're shorthanding refusal to deal with rivals. And I say recent cases because some of the big tech cases that we have been circulating in the discussion today have zeroed in on this element to distinguish refusals to deal from other types of Section 2 misconduct. So Judge Brinkman in the DOJ's Google ad tech case said Google's conduct is not a refusal to deal because the restraints are placed on customers, not competitors, and there was ad publishers. And so in DOJ's case against Apple, Judge Niels of New Jersey also found similarly in denying Apple's motion to dismiss. He said Apple's alleged conduct is not a refusal to deal because it's not directed at smartphone rivals. Instead, Apple was accused of maintaining its monopoly through conditional dealing with third parties like smartwatch or super app creators that use Apple's platform to reach end users. And that distinction has been drawn before in cases like Qualcomm, where the Ninth Circuit read Aspen as saying the prohibited conduct has to be directed towards competitors. So that's the second element that I would lay out as part of a refusal to deal that might be unlawful. And finally, and probably the most challenging element, is that to be unlawful, a refusal to deal has to meet some threshold as to its exclusionary nature and harm to competition. So the courts have employed all sorts of various tests here. The no economic sense test, which I think we're going to talk a little bit more about, which asks whether the monopolist's action makes no sense in the market but for its tendency to exclude rivals from competition. And there's other variations. The profit sacrifice tests, where we might look at whether the defendant is sacrificing short-run profit for long-run gain, and if the conduct would be unprofitable but for that later exclusion and the resulting market power, then we might find this element to be met. But Aspen and Trinco, these cases that are going to come up a lot today, say that profit sacrifice can show there's an exclusionary purpose, but they don't say such a purpose is necessary to a violation. Sometimes lower courts do treat this as a requirement. So here you'll see thrown around, and my students like these ones, even more specific requirements. Maybe the defendant has to have terminated a prior voluntary course of dealings, or maybe the refusal has to involve a product or service that was pre-existing, not created from the bowels of the company as it was in Trinco. So whether more specific or more general, this is getting at whether the conduct seems illogical for the defendant to engage in, but for some anti-competitive effects. So I'm confident that everyone on this panel has opinions about each of these elements, and so those are the three most significant as I see them. I think we could add to this list and debate each.
Thank you. Of course, if anyone in the panel wants to jump in, feel free. But Eric, I want to build on what Erika said. She mentioned that one of the elements is the short profit sacrifice or the making no economic sense prong. And in Via Media, the court said that, these are relevant, they're not dispositive. This is a 7th Circuit 2020 case. So a couple of questions about that. I know you wrote about that. How important are these considerations? Are these mandatory requirements? Do you have to show no economic sense or sacrifice? Are they really distinct from each other? Why the focus on short-term rather than long-term profit? And when you say sacrifice compared to what? So a lot to unpack over here, but these are very unclear tests or considerations.
So all of these tests are designed to diagnose anti-competitive intent. The basic idea. Since the earliest cases in which the Supreme Court talked about a duty to deal, it framed refusal to deal liability in terms of not only do you have to have an adverse effect on competition, but there has to be like an anti-competitive purpose. And I think the court's thinking was like, well, there can't be just a universal duty to deal. Firms are usually allowed to not deal with their competitors, but in the court's view, if you're refusing to deal with a rival because you want to exclude them, and this allows you to gain monopoly power or maintain it, then it's supposed to be illegal. So I think, by making intent essentially an element of the offense, that this is actually problematic. So I think, you ask, how important are these considerations? I think really this focus on intent is sort of a distraction from the things that most people who have thought a lot about this view as sort of the most important concerns. So as a policy matter, refusal to deal cases are somewhat distinctive in the sense that many people have this sense, and I certainly have it too, that there are a lot of cases where a firm might refuse to deal with a rival for purely exclusionary reasons, and yet we still think that liability would be inappropriate. And so, why is that? Well, the concerns that most folks have about having a broad duty to deal with rivals are twofold. So first, there's a risk of chilling investment in valuable technology if you have to share it with rivals. And the second is basically the administrative challenges of administering a duty to deal. It's hard. It might be, sort of de facto regulation. So, Trinko emphasized both of these. I think they're both important, but they don't have anything to do with exclusion. And so when you frame liability all around exclusion, even though most of us tend to think that exclusion might not be a sufficient condition for liability, then you've sort of set yourself up on a path where something bad is going to happen, right? Because you've got your principles that you think matter on one hand, and you've got this doctrinal framework that basically doesn't pay any attention to those things. And that's not a recipe for success. So let me just give you a hypo. So suppose that I spend billions of dollars and I create this network of satellites that can broadcast internet to people on the ground. And a rival comes to me and he says, I want to use your satellites to launch my own competing internet service. I'm going to use your same satellites. And let's just suppose, for the sake of argument, that I can accommodate this at no significant cost, that it wouldn't interfere with my ability to run my own service. But I'm going to say no because I don't want to have a direct competitor. I don't want to, if I could have no competitors, I'll make way more money, and so I'm going to say no. So on those facts, I've said no just purely because I want to exclude this rival. If the basic principles of the case law were faithfully applied, we would have to say that this is illegal. But I think most people would agree that this should not be illegal, that I should not have this duty to let the rival use my infrastructure because people won't invest in really expensive technologies if they have to share them with rivals. And the pursuit of monopoly profits is a big motivator. And if I have to share all my resources with rivals, and that's going to lead to intense competition, and then all of a sudden my monopoly profits are gone, then I'm not going to have an incentive to invest, right? So, the problem with current law, as I see it, is that, again, we've got these now very idiosyncratic liability rules, which are all sort of framed around Aspen, which is a very idiosyncratic case about ski resorts. Okay, it doesn't seem like a case about ski resorts should be so influential on platform conduct. But we're in this weird equilibrium where the Supreme Court decided that we don't ever want liability to extend beyond these sort of idiosyncratic facts of that case, right? But ultimately, the rules we're applying now don't make a lot of sense because they're not addressing the concerns that we care about, which again are like investment, administrability. I think it would make more sense if we had a doctrine that that tried to limit liability on the basis of those concerns. You're still going to have to show exclusionary effects in the end. So I don't think that evidence of exclusionary intent can be helpful to establish that exclusion is actually happening. But making it sort of the centerpiece, I think, is the main reason why this doctrine is so messy and so sort of disorganized and frankly not sort of nonsensical. So that's my take.
And I'll just add, we spoke earlier today about the Microsoft case, and in the Microsoft case, which was cited in the Google case, the EdTech case, the court said our focus is upon the effect of the conduct, not upon the intent. And the intent is just a way to basically get to anti-competitive behavior. So I'm completely with you on that one. Tom, building on that, in Via Media, the court gave, looking at Aspen, this very interesting credit skiing case, spoke about, I counted 13 factors. There was actually a table in that case about all the factors that may be relevant for refusal to deal. But I wonder, moving away a little bit from Aspen and Trinco, how does refusal to deal look today beyond those major Supreme Court cases? And I'm thinking about the US versus Google, the EdTech, where the court did address that and spoke about what the court sees the main factors for refusal to deal, if you can.
Sure.
And are we expanding it? Is it getting bigger or smaller? I know that some of us don't like refusal to deal, some of us are more accommodating. Where is it going to?
Yeah. Well, I think that you mentioned specifically the ad tech case and the degree to which the ad tech case is sort of faithful to Trinco. And I think it is. I mean, in that case, Google was accused of a number of exclusionary practices, but most prominently, it's tying of its publisher ad server to its ad exchange, AdX. And Google asserted Trinco as a defense, basically saying, I don't have a duty to deal with respect to AdX. And so if I say, I will deal with you, I'll let you use AdX, but you also have to use my publisher side server, then, since I don't have to deal with you at all, it's fine for me to deal with you on the condition that you agree to this other thing. And the court said, no. That's if we interpret unilateral refusal to deal in that way, we're going to eviscerate the law on tying and on exclusive dealing. I mean, all of those things could be conceived of as conditional refusals to deal. So we're not going to do that. And that strikes me as correct. I do think that there's been some slight expansion or some tweaks in the lower court's rulings that have tweaked the Trinco test a little bit. The way I read Trinco says, that aspen skiing is the outer limit of refusal to deal liability, and so you need to have the same sort of factors that we had in Aspen. One is a prior voluntary course of dealing. Commentators debate whether that's really required or not, but if, one possibility is you have to have a prior voluntary course of dealing. Secondly, you have to have a sacrifice of immediate profits, which suggests that you're giving up profit today in order to earn super competitive profits in the future once you've vanquished your competition. And third, you have to be dealing with others on the terms that the plaintiff is asking you to deal on, basically. So in Aspen, Aspen Ski Company would sell lift tickets to other people, but not to Highlands, basically. And I think that if we view those as kind of the requirements of Trinco, we do see some tweaks in the lower courts. So one of them, Erik was talking about, is the sort of tweaking of the profit sacrifice requirement to a no economic sense requirement. I think that actually makes quite a bit of sense. The profit sacrifice test seems to require two phases, like a predatory pricing case would, where you have an immediate sacrifice of profits and then later recoupment, earning super competitive profits. And people have pointed out, well, you can have a behavior that's actually immediately profitable for the defendant, but those profits stem primarily from anti-competitive harms, from exclusion, which allows earning super competitive profits, et cetera. But there's no profit sacrifice. You're immediately enhancing your profits. The no economic sense test would say, well, look, the test is satisfied as long as the agreement wouldn't be, or the action wouldn't be profitable, but for those exclusionary rents. So I think that's good, a good tweaking of the test. I think there's also been some tweaking on the prior voluntary course of dealing requirement. We actually saw this in the Fourth Circuit's Duke Energy case. Duke was refusing to deal with a rival, and it had dealt with the rival in the past, but it wasn't voluntary. It had been required to do so by FERC, the energy regulator, and so it said, this requirement of Trinco is not satisfied. There wasn't a prior voluntary course of dealing. And the court said, well, look, when the reason that we look to see if there's been a prior voluntary course of dealing is that tells us whether the dealing would be profitable for you. If you've voluntarily dealt in the past, it must have been profitable for you. In this case, while the prior dealing was not voluntary, it was clearly profitable for Duke, and that will suffice. So that's a little bit of a changing of the course of dealing requirement. And then one last thing where I think that it's not exactly clear what to make of Trinco. Courts seem to be limiting Trinco's constraints to questions of liability and not to remedy. So the issue before the court in Trinco, of course, was the liability of Verizon, not the remedy for any antitrust violation. But the concerns that the court articulated in Trinco are quite relevant to fashioning a remedy. The difficulty, if you're going to force dealing, you have to set the terms of the dealing, so the court has to act as a price regulator. Sometimes forcing dealing would require the defendant to build out facilities that it doesn't currently have, et cetera. All those things should give caution. So antitrust defendants have been citing Trinco in the remedies phase and saying, look, we shouldn't impose a remedy that requires that sort of price regulation, that requires building out facilities, et cetera. Google tried this recently in the Epic Games case in the Ninth Circuit. The remedy that was ordered by the court in that case required Google to share its catalog of apps with competing app stores, and that was going to require the court to sort of set the terms of dealing. And it was actually going to require Google to build out some facilities that didn't currently exist. And so Google said, Trinco bars this sort of thing. And the Ninth Circuit said, no, Trinco is relevant only to determination of liability and not to remedies. I'm not so sure about that. In the Supreme Court's 2020 NCAA versus Alston case, it talks extensively at the end of the opinion about remedies and the need for judicial administrability, et cetera, and it repeatedly cites Trinco in that discussion. So it seems right to me, I think the Ninth Circuit's right that technically that the narrow holding of Trinco deals only with liability phase and not with remedies, but certainly Trinco concerns are relevant to the crafting of remedies, and it'll be interesting to see how Trinco plays out in that context going forward.
And that's a perfect segue to Kristen. In Duke Energy, the court is discussing the different factors, and in one of them, the court is calling it the third factor for refusal to deal, and I'm quoting, is showing that the monopolist's refusal to deal was part of a larger anti-competitive enterprise. And then, for those of you who don't know, in both Via Media and Duke Energy, the court allowed the refusal to deal claim to go forward, despite Trinco. And that brings me to you, Kristen. So, in Duke Energy, the court is coming with what the dissent is calling in that case a monopoly broth. Think about the soup. I cannot squeeze exactly into refusal to deal. I cannot do predatory pricing. So I have something that looks anti-competitive but doesn't fit to any exact claim. I'm going to throw it into the pot. I'm going to make a mishmash. And now I have a cause of action. And the court in Duke did basically accept that in a way. And that's why the dissent was so upset. And we see since then a huge funneling of litigation into the Fourth Circuit. Everyone is trying to get a ball from that soup, maybe. So, Kristen, coming to you. So those decisions emphasize a possible avenue for litigants that we have not seen before, right? In Duke Energy, the court is saying you don't have to look at something specific. You can look at the entire course of action. So first, if you can help us just, for the audience who's not familiar with Duke Energy, what's Duke Energy about? If you can unpack that, what exactly was the Fourth Circuit approach, and what does that mean for curbing antitrust risk for litigants or future litigants with all of this above approach?
Yeah. I think Duke Energy is an interesting contribution to this conversation because, as you say, Shahar, the court's very clear. It's considering the defendant's alleged conduct as a whole, and it's critical of the district court for taking a sort of overly siloed approach, for trying to fit each aspect of the defendant's conduct into an established doctrinal bucket. I'm not sure, though, reading the opinion, how much that statement was necessary or impacted the outcome in that case specifically, though, in which case the decision sort of gratuitously muddies the waters, I think. So in Duke, the plaintiff, NTE Carolina, it's a power company. It's trying to get into markets in the Carolinas. And it sues Duke Energy, which has about 90% of the power generation in the region, and importantly has a lot of the transmission lines. So NTE, in order to compete, it has to win customers away from Duke, but it also needs to transmit its power over Duke's lines. And the Court of Appeals sort of focused on two aspects of Duke's conduct. First was a contract Duke had with one customer, the city of Fayetteville, and the second was the decision to cut off NTE, after previously allowing them to transmit on their lines, to cut off access to the transmission lines. With respect to the contract, the court concludes there's a factual dispute about whether or not the contract pricing is predatory. There's sort of an upfront discount on some power that was on the legacy contract that NTE couldn't have competed for, and then go forward, the prices were going to rise later. To be sure, the court cites a lot of other evidence, including ordinary course documents that basically, according to the decision, Duke admits they're not as efficient a competitor, they can't compete on price with NTE, and they constructed this contract in order to prevent that competition. But all of that is largely context. At the end of the day, the court relies on there being a factual dispute that the contract flunks the doctrinal tests for exclusive dealing and exclusionary contracting. So nothing particularly controversial there. Then turns to the refusal to deal, and it finds evidence that Duke terminated a profitable arrangement with NTE, and that the purported justification was bogus. So not unlike the tests that Tom was just talking about in terms of a refusal to deal. Then they go on to say they don't have to decide in isolation whether or not the refusal is lawful because the conduct was but part of a larger scheme. And that language, which is what you were referencing, Shahar, that's the very same sort of concept in then Judge Gorsuch's decision, the Vell decision, where he says a valid refusal to deal claim requires the refusal to be part of a larger anti-competitive enterprise. So again, I think the court could have just held there's enough evidence here to go to the jury on the elements of a refusal to deal claim, or the familiar evidence to the extent that we can discern them. But the court doesn't say that. Instead, it makes this statement that gives courts in the Fourth Circuit license to issue these traditional tests and consider instead this sort of nebulous totality analysis, which is what leads to the monopoly broth charge. Of course, once you blend everything together, these doctrinal guardrails start to lose their force, and the unclear boundaries that everyone's just been talking about become even less clear. So from a risk standpoint, it really matters for companies trying to figure out whether their conduct does or does not run afoul of the antitrust laws. A defensible business rationale for each action is necessary, but evidently not necessarily sufficient to avoid liability. And the line between an overarching narrative that suggests aggressive competition versus an overarching narrative that suggests exclusion is even more difficult to draw, I think, than the issues we've been talking about.
So bad news for certainty and businesses, but great news for lawyers. More job. Okay.
Shahar, can I give some thoughts on monopoly broth?
Please,
If we have
by all
time,
means.
yeah, because I
Do
think
you want to add some spice to it? Go ahead.
absolutely adding some spice to the soup. No, I think Kristen said it exactly right. Where monopoly broth as a controversial idea, and courts are accidentally sort of bringing it into decisions where they don't need it. And I would put ad tech on that case as well, in that list of cases where they're sort of muddying. I think that for antitrust people in this room, it's worth disentangling monopoly broth claims, which we could debate whether they exist, from less controversial things that are getting intertwined with that debate. And I see at least two things that we can disentangle here. So the first one being, when courts say they're going to consider the course of conduct of the defendant in a Section 2 case, that shouldn't immediately be controversial, right? There's no single act in a Section 2 case of monopolization. There's a number of acts. There's a bunch of acts, and together they might give the court a better understanding of what the anti-competitive effects are. That doesn't mean it's a monopoly broth case, right? Or every Section 2 case would be monopoly broth. So that's got to be sort of disentangled from it. And I think the other thing to disentangle, where the Duke Energy Court wasn't wrong, was that the defendant was essentially arguing if this conduct is not within these categorical tests, it cannot give rise to liability. It is outside of antitrust scrutiny. And that would mean that the categorical tests we've developed in Section 2 are all there is for Section 2. And that's sort of the wrong way around, right? We have these tests to identify anti-competitive conduct, but they shouldn't supersede the question of whether there is anti-competitive conduct. And so I think disentangling that is important too, and we can echo back to Microsoft where we started today, which says why we need to do this. The means of illicit exclusion are myriad. Section 2 is not a closed sort of set of court-made subcategories that we check the box on. And so although that can be more difficult, both for courts and for defendants, I think it sort of has to be true under Section 2. And whether we recognize a monopoly broth type claim is a separate question from whether Section 2 is a closed set. So I think if you haven't read Duke Energy, it's definitely an interesting read, and it's very sad that it didn't get cert.
I'll add to that Section 2 categories shrunk lately, right? With link line, we had price squeeze up to a point, and then came link line, and with something that seems like a complete arbiter because both parties were on the same side, the plaintiff and the defendant, but we got somehow rid of price squeeze as well. Erik, both you and Tom mentioned platforms. And refusal to deal issues often, they do arise in platform, especially where the platform is vertically integrated and allegedly discriminates against rivals on the platform. We've seen allegations involving Apple and third-party apps, Amazon and marketplace sellers, and Facebook bearing competitors for access. Should platform be treated differently? And do we need a distinct standard for multi-sided platforms?
Yeah, it's a good question. So I don't know that we need a special rule that's just for platforms. I also don't think that sort of minor acts of self-preferencing should be regarded as an antitrust issue. Like if Amazon puts its own product at the top of the page on Amazon.com, I don't see that as serious enough to warrant antitrust attention. But I do think that antitrust has sort of a blind spot when it comes to unilateral conduct. That there are some problems in that area, and that those problems are most apparent and most acute when you look at platforms. So the blind spot, I think, is that there are cases where you've got unilateral conduct that is sort of economically equivalent to tying or exclusive dealing, but which courts would categorize as a refusal to deal. And that the sort of most obvious situations where this can happen is on platforms. So just as a hypo, just think about the Microsoft case. So we often talk about that as a tying case. That it happened to involve, for example, vertical agreements, also some unilateral design changes. But suppose we had changed the facts. Ultimately, what Microsoft wanted to do was to make it really hard for consumers to use a competing browser on a Windows machine. Suppose that instead Microsoft just, it required everyone to go through a Microsoft-approved app store, like the ones on our phones, and then it just unilaterally refused to let any competing browsers onto the store. Right, so that would have the same effect of making it hard or impossible for consumers to use a competing browser on Windows. But now, because the courts are very formalistic when it comes to refusal to deal, they're probably going to call this a refusal to deal. And what's problematic, I think, is just to think about how stark the difference is in terms of what the legal standards we would apply then become, right? So instead of this very open-ended analysis for Microsoft, where we're thinking about foreclosure of rivals and so sort of potential pro-competitive justifications, those are really the two focal points. Instead, we're talking about, like, do you have a history of prior dealing? Did you sacrifice profits? These very sort of formalistic rules. I don't think it makes sense that, if two practices are basically equivalent from an economic standpoint, that we would subject them to such different rules. So I think, with one caveat, I think that if a platform, for example, just removes a competing app from its store and cannot give any sort of pro-competitive rationale for that we should sort of treat that like tying. That doesn't mean it's automatically illegal, but it does mean that we should apply the kind of analysis that the Microsoft court applied. The caveat is that there could still be administrability reasons for not intervening in cases like this. One difference between tying and refusal to deal, even in cases like this, is that enjoining a tie, which is usually an agreement, is not that hard, but imposing a duty to deal can be hard. So with platforms, though, it's often the case that it ends up not being that hard, because if I allow 1 million apps on my platform and I set the same terms for all of them, then the court can just say, well, you just have to offer those same terms to the rival that you excluded, and it ends up not raising significant administrative concerns. So, ultimately, I think the problem is that we're very formalistic right now in the way we treat unilateral conduct under Section 2. That we're actually not quite as bad about it in other areas. So there's a famous case, Lorraine Journal, where a newspaper basically told its customers, advertisers, if you run any ads on my competitor, which was a radio station, I won't do business with you. So this is unilateral, but you can see that it sort of has the same effect as exclusive dealing, and so the court basically treated it like exclusive dealing. I think the logic is straightforward, right? If unilateral conduct behaves economically just like a vertical restraint, then why not just treat it that way? We're not yet doing that with refusal to deal. So I see that as a problem that comes up potentially in platforms, but I wouldn't say that it's sort of unique to that context.
Erika, I wanted to ask you, in one of your articles, you introduced a concept called antitrust abandonment. And as far as I understand, the idea is that regulators sometimes have the statutory authority, right? We saw that in Duke, in Trinco, DOJ, FTC, to enforce antitrust law, but they fail to do so. And you also explained that Supreme Court decisions often treat regulation and antitrust as substitutes. How does this substitution logic operate when we come and speak about refusal to deal?
Thanks, Shahar. So this kind of echoes back to some of what Tom was talking about in Duke Energy, so I'll tie together the discussion, because at lunchtime we heard, regulation and antitrust are being discussed very much in the same house today, and I think they're both levers to ensure competition in markets when we talk about competition regulation. I think it's important as we talk about Trinco to remember it happened in a heavily regulated industry, right? But there, Trinco's saying the existence of a regulatory regime that performs the antitrust function means that antitrust, the benefit of antitrust enforcement is small, right? And that's because in that case, the regulator, the FCC, was engaged in really active regulation. And so my paper is about other scenarios that don't really fit into that Trinco assumption, which was true in that particular context. So antitrust abandonment, which is out with Yale Journal on Regulation, is looking at the many other regulators who do not actively use their antitrust-like powers. So their powers have been abandoned. And I look at the enforcement track record for 3 different regulators in meatpacking, regulated rail, and ocean shipping, which may not sound sexy, but they do a lot to get things across the United States and are really important industries. And those 3 regulators have statutory powers that look a lot like antitrust. Some have never used them. Some have used them a handful of times over a century, okay? So these regulators at some point were so lax in their oversight of competition that DOJ would be submitting these protest filings to force the regulator in shipping to actually look at some of the conduct, or publicly opposing anti-competitive mergers in rail, where you see a sort of DOJ against a regulator. But that sort of abandonment changes the calculus from Trinco, right? Antitrust becomes more pressing and important where the regulator is not taking up their antitrust function or ambit. And we can tie that back into the Duke Energy case, which is sort of a third scenario where FERC had powers to intervene in anti-competitive conduct and had used them, but the court says it used them ineffectively. It took so long that the anti-competitive conduct had occurred and there was a 20-year contract in place that could no longer be disputed. So there's different sort of scenarios where antitrust is actually still quite important in regulatory context. We think we sort of think of them as two sides of the same coin, but we can get a lot more granular in when antitrust is really important in regulated areas, like in antitrust abandonment or in the Duke scenario.
Kristen, I want to ask you something that I think only a practitioner will be able to tell us. I teach that in my Antitrust 1 class, but I wonder how much you see that in practice. So there is this idea about, this is Section 1, Section 2 boundaries. The idea that firms are stuck between a rock and a hard place. You deal with a rival, you risk a Section 1 liability, collusion. You refuse to deal with a rival, you risk a Section 2 liability, refusal to deal. From your experience on the ground, does that reflect how businesses actually think and try to curb what they're doing?
So I don't have any clients that are spending a lot of time noodling on which doctrinal bucket they're sitting in. I think there's some intuitive appeal to that, but it probably overstates the tension, right? Because simply choosing to deal doesn't land you in Section 1 liability, create liability under Section 1, nor does refusing to deal automatically result in a Section 2 violation. There are other elements here that have real impact, right? The agreement has to unreasonably restrain trade. Section 2, you need monopoly power. So I think in the real world, liability turns on a lot of these other aspects. So from a practitioner's perspective, in addition to not being nearly as interested in these boundaries as everybody in this room, the clients aren't sitting around deciding which statute they're falling under. They're thinking about whether the particular strategy makes business sense, right? How is it going to affect our customers, our competitors? How is it going to be looked at and perceived by a regulator or a court? I always start with who's going to be upset about this and why, and that tells you a lot about where you might run into problems. So I don't see it as a rock and a hard place. I think the more accurate question is whether there is a legitimate business rationale, whether the decision reflects competition on the merits. If the only way to profitably deal with someone would violate Section 1, then declining to make that deal can hardly violate Section 2.
And the only reason I mentioned that there is a footnote in the Aspen case, where, which was the refusal to deal case, of course, that's the main case. But in that footnote, actually, they were sued, the skiing resorts, for colluding by the AG. And then they got into a consent decree that ended up later on as a refusal to deal. But I'm happy or unhappy, I don't know, depending on
I think there's a big difference between collusion among competitors that violates Section 1 as opposed to a decision. Some of the conduct that we've been talking about, right, sort of conditional dealing, that does expose you potentially to Section 1 liability. But yeah, as I say, I think it's a more academic question.
So Thomas, the academic over here, one of the academics. So, we speak about refusal to deal usually as a sword. We're trying to sue someone saying, you refuse to deal, you should not have refused. But in some cases, it can be also a defense. When does that happen exactly? What kind of context can you think about that happening as a defense? One thing I'm thinking about is maybe link line. I'm being sued. I had no duty to deal with you. So whether there was predatory pricing or not, who cares? I don't have to deal with you at all.
Sure.
Take any price I give you.
Yeah, I mean, link line is the most obvious example of this. In that case, for people that aren't familiar with the case, we had a vertically integrated monopolist that provided wholesale internet access basically to internet service providers, and then also provided retail internet service, and raised up the price, its wholesale price for access to its network, and at the same time lowered its retail price, which meant that retailers that were buying internet access from, or network access from that company couldn't profitably compete with it in the retail market. So it's a classic price squeeze, like in the Alcoa case. And the Supreme Court basically took sort of a divide and conquer strategy in analyzing this price squeeze, saying, look, it's composed of two parts, hiking up the wholesale price and lowering the retail price. And the defendant here doesn't have an antitrust duty to deal at all in the wholesale market. So if it wants to deal but by charging high prices, it's free to do that. And then its prices in the retail market are not predatory, they're not below cost, so there's no predatory pricing. So basically we have a two-part scheme here where each part is legal and there can be no liability. So that would be an example of using the refusal to deal doctrine kind of as a shield if refusal to deal is a necessary component of some anti-competitive scheme and you don't have a duty to deal, then it seems like the anti-competitive scheme couldn't create liability. But that brings us back to the Duke Energy case, which is really, we had the same sort of thing there. Refusal, or there was a duty to deal was kind of part of the scheme. There were, I think, 5 components of the alleged anti-competitive scheme in Duke, and each of them, if you considered it in isolation, there was no violation, and so the defendant's position was essentially 0 plus 0 plus 0 plus 0 plus 0 equals 0. There's no liability here, and as Kristen and Erika were discussing, the Fourth Circuit said, no, that's not the case. We have to consider this as a whole. And I have to say, so I'd be interested in Erika's thoughts because she is pro-broth, sounds like.
I do like soup. Is that what you're asking?
I'm having a really hard time distinguishing Linkline from Duke Energy. The court cited Linkline in the Duke Energy case, and it cited it approvingly, basically. It said that when there is a conduct-specific test for some well-understood antitrust behavior, you just apply that test. That's fine. But when you've got a scheme that's too elaborate or maybe novel, then that's not sufficient. And so I'm trying to figure out what's the difference in Linkline and Duke Energy. I mean, one difference is 2 parts in Linkline versus 5 parts in Duke Energy. The other thing in Linkline, the practice at issue, price squeeze, is something that courts have had lots of experience with. We've got the famous Alcoa case, the Cargill case from the Supreme Court, a merger case involved a price squeeze theory. So we're familiar with price squeezes, and the combined strategy in Duke Energy was more novel, but I have to say I'm actually kind of baffled. I don't know how to reconcile Duke Energy with Linkline. So back to your question, Shahar, I mean, I think that the refusal to deal doctrine, and Trinco in particular, which so drastically cuts back on the refusal to deal liability, can be a shield, but Duke Energy suggests it maybe has some holes in it if the duty to deal part is too small a part of the overall anti-competitive strategy. Simply proving that there's no duty to deal is not going to prevent liability.
Erika, I want to switch to speak about the boundaries between tying and refusal to deal, something that, a number of you mentioned already.
I have to talk about soup first, right?
Oh, sorry.
No, I'm just kidding.
We're into the soup. Totally go for the soup.
I think Tom did, if you don't mind, Shahar.
I do not.
I think Tom asked a really good question, which is like, what is the difference between the Linkline case and the Duke Energy case? And I think what Linkline was saying was, all there is here is predatory pricing and a refusal to deal. And the court sort of leaves open, like, because there's nothing else happening, because all of the conduct fits within these recognized categories. There's no need for another Section 2 violation to be created to address some sort of residual anti-competitive conduct. Whereas I think in Duke Energy, what I hear the Fourth Circuit saying, and we can agree or disagree with them, right? But is that whatever this conduct is, it's not within a predatory pricing test only. It's broader, whatever the 5 things are, and there's a lot of them, right? There's sort of retroactive discounts and above market pricing for other sourcing that happened in that case. And so at least on a summary judgment, in Duke, they're saying, we're leaving open the potential for there to be some other violation here. So it doesn't necessarily have to be a broth violation, but like a new category of Section 2 misconduct. Maybe we decide to recognize it ultimately at trial, maybe we don't. But I think Linkline's consistent with that, because it was saying, if there is something more than what's covered by the categorical test, then show us what it is. And there was nothing in that case, and maybe there's something in Duke Energy. Does that resonate with the two? No, still no?
So I want to add go ahead, Kristen.
I would just add, I think this comes back to maybe where Erik started the conversation about whether the role of intent in understanding how this, right? Because I think the Fourth Circuit seemed undoubtedly persuaded by a lot of, the ordinary course documents and the evidence that this really was constructed with a very particular purpose. And that, I think that wildly influenced the outcome there. And so I think it comes back to this question of what do we think about intent and what it tells you about effects and whether we're indexing on the former or the latter. I think that's a distinction that also influenced the outcome in Duke.
Anyone else about the soup before we proceed? By all means.
I'll just add that.
Yeah, here you go.
If you do what I think courts should sometimes do and say that some refusals to deal should just be lawful without regard to intent, then a case like this might just become really easy, because you might just say, well, if there's predatory pricing added on, it doesn't matter because we've already decided that there's no duty to help your rival stay in business here, and so we're done. So there are administrative benefits to taking that position too.
And Erika, to your point, I have a nice quote from Duke Energy. The court says, plaintiff alleges complex, atypical anti-competitive conduct that does not fit neatly within pre-established categories, which is your point. So since we don't have the right bucket, we don't have any bucket, we're trying to figure things out, and that's also the soup. Moving on to tying and refusal to deal. Okay. So Erika, if you can tell us just before we start into tying, just the one-on-one elements of tying. How does that work? I know that we have great elements. We're not sure if it's per se or rule of reason. We'll address that as well. But what is tying exactly? What are the elements?
Sure. So I'll keep this relatively brief since I'm doing the role of introducing the elements on all of these things. So I think when we talk about tying, we're talking about the conditional sale of one product you have to buy another product. And I think that's not the unlawful part, right? Tying can be beneficial to consumers. Like, I'm delighted my new smartphone came with a plug that fits it, as tying two products together. But we're talking about tying that can violate Section 1 or Section 2 of the Sherman Act, and we could keep going, like Section 3 of the Clayton Act, Section 5 of the FTC Act. But I think we're interested in sort of the Section 1 and 2 part of tying. Tying from a monopolist can satisfy the anti-competitive conduct element that I talked about under Section 2. But most of the definition of the elements of tying comes under Section 1 cases. So I also teach patent law, and a lot of the classic Section 1 tying cases are a patented product being tied to an unpatented product, which the courts treated as per se unlawful, right? If you want my canning machine, you must buy salt. And so there were 4 elements which Microsoft explains that are pretty well articulated in the law. The tying and the tied goods have to be 2 separate products. That sounds easy until you get to technology, which as it moves forward tends to integrate more and more separate products. The defendant has to have market power in the tying product market. There has to be some sort of coercion, according to Microsoft, where the defendant is not affording consumers a choice to buy separately. And then the tying arrangement has to foreclose a substantial volume of commerce in the tied, so the second market. But I think this comes to a case that we've been talking about a fair bit already from the Seventh Circuit, via media or via media, depending on how you pronounce it, that has sort of disclaimed the need for that sort of very specific element-based analysis of tying under Section 2, although it engages in that analysis, saying sort of where there is proof of monopoly power, maybe we can be less categorical in our analysis of tying. So I'll leave it open to others to comment on whether we're getting this right or not, but that is sort of how the elements of tying have been defined.
Now, Tom, I know that you want to speak about per se versus rule of reason. What is it exactly? But hold that thought for 1 second, just in the interest of timing, sorry, not tying. Speaking about the boundaries between tying and refusal to deal, you mentioned via media. The court over there, the plaintiff relied on both refusal to deal theories and tying. And the lower court dismissed those two claims, and it noted, I'm quoting, many of the practices that have been characterized as exclusive dealing could also be described as tying, because the economic distinction between them is very minute, if you want. So Erik, what do you think about that? If a secondary refusal to deal category acts substantially the same as a tie, can a plaintiff avoid some of the doctrinal hurdles in one of those doctrines and file under the other doctrine? Or does those different buckets really limit you to each one of those, and if you don't fit, unless there is a soup, you don't fit?
So I think it's still a little bit open-ended, or more specifically, I don't think it's fully resolved yet. So the court in via media said that you could. Actually, if you look at the MCI versus AT&T case from a long time ago, the same thing happened in that case. The case was mainly about essential facilities, but the court also found that AT&T was sort of committing anti-competitive tying. But there are also examples of cases where courts have said, no, you're pleading this thing. Sometimes the plaintiffs don't call it tying, they would call it monopoly leveraging or something like that. And the court has said, no, actually that's not what it is. It's a refusal to deal. So what we have is a lot of inconsistency. So it's not clear.
Anyone else wants to address this question? Okay, Tom, if you don't mind briefly about, is tying a per se, subject to per se analysis or rule of reason analysis? I know that most people think it is more like a rule of reason analysis because you have to define the market and assess market power, and you can introduce pro-competitive justification. And then if you did that, the court has to balance, which sounds exactly like a rule of reason analysis. But then we have some folks like Anna Elhog, pushing to the other side, yes, per se. So where do you stand on that divide?
Well, I mean, the Supreme Court says it's per se illegal. I mean, it's a weird per se rule. We often refer to it as a quasi per se rule. And in the Section 1 context, you have to have two separate products that are tied together, market power in the tying product market, and then it affects a not insubstantial dollar volume, not for percentage foreclosure, but dollar volume of sales in the tied product market, and then it's per se illegal, but we're going to let you articulate pro-competitive defenses, which is we don't usually allow in per se cases. So it's a stupid rule, and
You really think?
it's really the worst of all possible worlds because we get the administrative costs of a rule of reason assessment. You've got to define the market and establish tying market power. That's extremely, resource intensive. But yet we don't get the accuracy of a rule of reason analysis because there's a presumption of illegality as soon as you establish that those elements are satisfied. So, Justice O'Connor in the Jefferson Parish case said, this is stupid. Why are we incurring all this cost when reducing our accuracy? Let's just treat this as a rule of reason offense. And going back to the sort of overlap between tying and exclusive dealing, if you look at Jefferson Parish itself, it really was an exclusive dealing case. This hospital had entered into an exclusive dealing arrangement with some anesthesiologists, and as a result of that, customers who bought surgery there had to use one of those anesthesiologists, If you analyze it as a tie-in, it's assessed one way. If you analyze it as an exclusive dealing arrangement, it's assessed a different way. That's stupid. So Einar Elhage is a lovely person, is defensive of this quasi-per se rule on the grounds. So people like me who are critical of the per se rule, and I think Erik, you have written similar stuff with your dad on this, have said, look, we should treat exclusive dealing and tying similarly, focusing the way we do in an exclusive dealing case at the outset on the percentage of foreclosure occasioned by the arrangement, and then assess competitive effects from that. So if we treated tying that way, we would say, like, what's the percentage of foreclosure in the tied product market occasioned by this tie-in? What do we think the anti-competitive effects might be? And that would reconcile tying and exclusive dealing. Einar Elhage says, no, we should stick with the old rule because you can have adverse effects from tie-ins that do not involve substantial foreclosure in the tied product market. And the quasi-per se rule catches those, and the rule of reason analysis that that I'm in favor of does not catch those. And then he describes what they are. One is something like a price discrimination using a variable proportions tie-in. People are probably familiar with this, but you sell the printer don't charge your profit maximizing price, charge a lower price for your printer, but then require everybody to buy your ink. And that way you charge a super competitive price for the ink. That way you are effectively charging higher prices to people who value the printer a lot and lower prices to people who value the printer less, and that allows you to extract more surplus. So that would be one sort of surplus extractive effect of a tying arrangement. The famous block booking of films case, the Lowe's case, involved a similar situation where tying was used to extract greater consumer surplus. He lists 3 different areas where tying arrangements that don't occasion substantial tied market foreclosure can nevertheless injure consumers by extracting consumer surplus. All well and good. He also points out that the Supreme Court, in its number of its tying opinions, has pointed to these price discrimination effects as adverse effects of tie-ins. And he says, well, the court calls them anti-competitive, we should recognize that. They do not, however, involve what I think is kind of the essence of an antitrust violation, which is that you have done something to increase your surplus extractive power by weakening competitive constraints. The tie-ins that he's talking about, metering tie-ins, et cetera, do increase surplus extractive power, but they don't weaken competitive constraints. And for that reason, I don't think they should be antitrust violations, and so I'm not in favor of keeping the per se rule as Einar is. I'd rather just treat tying and exclusive dealing in a similar way because they're very similar practices.
Sounds good. We have about 12 minutes or so. Let's open it to discussion, Q&A, so if anyone has any questions, we'd love to entertain them.
So earlier today we talked about the Microsoft case, which was sort of a structured rule of reason, arguably competitive effects analysis. We don't really see that type of analysis in many of these cases you're talking about. There are sort of rules, and we try to fit conduct into specific rules. One of the questions I didn't want to ask the panel earlier this morning, but there was some sense that the Microsoft adoption of sort of a rule of reason approach in the Section 2 cases might allow for further development of case law in these areas where the question was a little bit tougher, outside of just putting things in particular boxes. So I'm kind of wondering why Microsoft failed the structured rule of reason of Microsoft sort of failed to address some of these questions, or why it wasn't used by the courts in these questions?
So I think the answer I would give is that this comes back to the idea that there are a lot of refusals to deal where we don't actually think that exclusionary effects are a sufficient condition for liability. If we actually did what we claim to do, which is to ask if a refusal to deal is exclusionary, that we would have a ton of liability, but that courts recognize that that's a bad idea. In fact, Justice Gorsuch in a case called Novell basically acknowledges that, well, why do we have all these idiosyncratic rules from Aspen? Why do we require them? He does not say that they make sense. He just says, because we're worried about chilling investment, and we're worried about not being able to administer antitrust remedies. So Microsoft is a case where we think where the normal sort of the default approach to Section 2, which is that if it's exclusionary and it's there's no pro-competitive justification, then it should be illegal. So it makes sense that in a case like that you would have a detailed investigation of effects. If you don't think that exclusion is actually a good basis for liability, then you don't want to actually dig in to those economic effects because you don't want to have to find liability. So I think that that's the difference. That right in Microsoft, we thought that if it's exclusionary, it should be illegal, and in most, or at least many, refusal to deal cases, courts actually don't believe that.
Anyone else? Or any other questions from the audience? Here,
Hi there,
please.
Chris May with MLEX. Thanks for the conversation. We've seen some lawsuits alleging from publishers against Google regarding AI overviews, and there's some sort of novel claims about reverse tying or reciprocal dealing, and I'm just curious where you all think sort of that fits into this conversation about if you're selling something as opposed to buying something, is that still tying, or what is it?
Can you give us some more context exactly what you mean, just in terms of the patterns? Yeah.
Yeah. So the gist is, if you're a publisher, you provide your content to train Google's AI, and in exchange you get search traffic, and so you're conditioning search traffic through Google Search on providing the content to train AI, and so you're essentially tying access to search results to the sale. There's no price. The sale of your content.
So, Erik,
Yes, so it's not really tying, right? It's just a non-price, it's an exchange. You're just paying in services instead of a price. So I would think you would analyze it similarly, just with the caveat that it's a non-price market. So you have to do some extrapolating to figure out whether or not you've got a diminution in quality, or how the potential exclusion is manifesting itself, right? Because you can't be looking at price, but otherwise I'm not sure it would be different.
Let me ask the panel, is that different, for example, from a privacy barter? So I can go and have a Gmail account, but only if I give away my entire privacy. So it's another quid pro quo without just another monetary one. Do you think it's more or less the same, or it's very different than the situation?
I think the privacy quality competition paradigm is a little bit more developed than whatever that novel claim sounds like. And on this, I'll shout out on John Yu and James Cooper have some great work on this. So in some markets, there is competition related to privacy. In some, there is not. We don't fully understand the causal relationship between the two. If I can very briefly summarize, they're more complex and nuanced work. And so I think that no, it doesn't sound like it's the same paradigm.
Any other questions? So Erik, let me push you on a paper that you published in the Yale Law Journal, in which you make a distinction between a primary and a secondary refusal to deal. And for the first one, which goes back to what you just commented a second ago, if I understand correctly, you recommend a presumption of lawfulness for the primary type of refusal to deal, but not for the secondary one. So you gave the satellite example earlier. I guess that would be a primary refusal to deal, where I'm not allowing my competitors to compete with me directly on my infrastructure. What would be a secondary one, and why the different standard for each one of those?
So the secondary category is just meant to identify the cases that are basically equivalent to tying. And so I think that almost all cases that don't fit into that category and maybe into the category that Erika mentioned should just be legal without regard to whether there was exclusion. Again, that's because the main reasons that the Supreme Court, but also like economists and other antitrust experts give for why should we not have a broad duty to deal, don't have anything to do with whether you think that the refusal was exclusionary or not. They're about protecting incentives for investment and making sure we can administer some remedy before we try to do something. And so, I think that right now we're in a situation where there's basically no liability in any cases. I think the problem is that the rules that we have in place do not do a good job of distinguishing what cases might be meritorious from the ones that are not. And that what we should really do is just acknowledge that there are a lot of cases where we just think that it should be basically per se legal, and then try to identify the subset of cases where we think that actually there is a basis for, we have some reason that we don't think we have to worry about the incentive problem and the administrability problem. And in those cases, we can just do a Microsoft-style sort of foreclosure analysis, which to me makes more sense.
Now, for me, a per se legal analysis or per se legal result is quite revolutionary in antitrust. Right? We have nothing that is per se legal right now. It's either rule of reason or per se. Maybe the filed rate doctrine. So if the agency requires me to charge a certain price, and that's what I'm doing, then I'm immune. It's per se legal. Anyone on the panel thought about per se legality in some context?
I mean, I think one situation where I might think about it, but it's really hard to say when it isn't, is the sort of predatory innovation allegations where it's a product design change that turns two products into one. And that's very difficult for the court to weigh in on whether that's an improvement or not. So I'm thinking here of Allied Orthopedic and those lines of cases. I'm not advocating for per se lawfulness, but I think that gets you close to sort of the problems that Erik seems to be talking about.
So I love that. Kristen, you had some thought about how the remedies maybe drive notions of liability or the administrability of possible remedies, which is what Kristen is speaking about. Erika is speaking about.
I think that's a species of what Erik is speaking about. I think you're making, well, I won't speak for you, but I think there is a more fundamental flaw with a sort of predatory innovation theory than just it would be very difficult to manage how you deal with remedies. But it is true that I think and we touched on this earlier, the difficulty in administering a remedy, particularly if that remedy requires intervention in product design, I think does influence outcomes as a practical matter, because while it's true that courts never want to be a market regulator, they really don't want to do that kind of regulation, and with good reason. So, but I think the flaw and maybe the argument for per se legality for product innovation is more fundamental than that.
Okay. Any questions from the audience? We have about 2 minutes. You can take something very quick. Go ahead.
There's some question about how technical is on collateral. We're going to apply the rates to the flow stand. That's going to be easy for the defense to do. But when you have another product design that involves some leveraging of technological time, still a product design, but there's leveraging. We're going to apply much higher standards. I mean, isn't that sort of a disconnect? Like, why is there leveraging involved in design? It's a very high standard. But if you're just making one product, it's almost going to be always. I mean, is that their potential?
I think you can potentially resolve it by saying, look, two competing principles. We think if you earn a monopoly on the merits that you get to keep it. That's not a violation. On the other hand, if you earn one monopoly in this market and you exploit that to impair competition in a complementary market, that's not allowed. And that's sort of the basic premise of tying. And so that's one basis for potentially drawing that distinction. Yep, that's true.
Our time is up. I want to please join me in thanking the panel for a very exciting and interesting conversation.
like we should chat more about, we don't agree with the one sign some distinction.